Good afternoon, everybody. Welcome to the first event for the law school and the Frederick K. Cox International Law Center for 2008. And we're really excited to start the new year with a fantastic lecture. This is our annual Klatsky lecture. And the Klatsky lecture has been funded by an endowment by one of our alums and a trustee of the university, Bruce Klatsky, who was very active in Human Rights Watch, and he wanted to set up a lecture series and also a position for our students every summer at Human Rights Watch. We've had, as past Klatsky lectures, Pulitzer Prize winning authors like Samantha Power, International Tribunal prosecutors like Richard Goldstone, the head of Human Rights Watch last year, Ken Roth, and we're really excited that this year's Klatsky lecture is Michael Reisman. Michael Reisman is quite literally the Dean of the International Law Academy. All of the professors that teach international law, we want to be Mike Reisman, and it's great to have him here. Mike has been both a fantastic professor and writer of 22 scholarly books, but he's also been in the real world, where he's been the president of the Inter-American Commission of Human Rights, which gives him the credential, I think, to talk about today's subject. He's also been an active international arbitrator, and he is going to give us some very interesting insights. There's going to be some provocative thoughts that are going to get our juices boiling, and at the end of his 45 to 50-minute speech, there will be 10 minutes of Q&A. We do realize that people all over the world are watching this. There's over 100 people in this room. There's another 100 people upstairs. And we're real excited that there's such a great turnout for this event. This is part of our year-long group of events to celebrate the 60th anniversary of the Genocide Convention. And we had, as some of you remember, a large symposium in September about the convention. We had a speech by Luis Moreno Ocampo, the chief prosecutor of the International Criminal Court, in October, and now we have Michael Reisman, which is the last part of this. And then finally, at the end of this month, on January 29th, mark your calendars, we're going to have the 5 judges who presided over the trial of Chemical Ali before the Iraqi High Tribunal in Iraq, coming here to tell us about the challenges they had facing off against originally Saddam Hussein and then Chemical Ali, and whether or not their trial was fair will hold up to international scrutiny. But without further ado, let me ask you to give a warm welcome to our Klatsky lecturer, Michael Reisman.
I'll perch on this bar stool since I don't plan to stand for 50 minutes. I thank you very much for that generous introduction, Michael. Ladies and gentlemen, I'd like to start on a very gruesome and terrifying note, and that is the prospect of any one of us being murdered. The taking of life is the ultimate and the irrevocable violation of human dignity. And I think for each of us, it's the ultimate terror. Because each of us fears being murdered, we all look to our various communities for the protection of our individual lives. Thomas Hobbes laid motives of this sort at the very foundation of the modern state. And Professor H.L.A. Hart, the great jurisprudential writer, argued that it was one of the reasons why we have to have systems of law. He observed that even the strongest, the most powerful person sometimes has to sleep. I think it's fair to say that the raison d'etre of the modern state and a major purpose of international law which stands behind them is the provision of security, which means the protection of individuals and which means, in each of our individual cases, preventing individual murder. Yet, for all the urgency that each of us gives to this ultimate and most individualized form of personal security, and for all the intensity of demand that we make on our governments to guarantee it, there is little that any government, even the most authoritarian and controlling, can actually do to prevent single acts of murderous violence. Democratic governments face even greater obstacles in fulfilling this guarantee because For important policy reasons, they must resist proactive preventions, so they must look to other methods. One of the methods is long-term socialization, trying to train people not to express the violence we're all capable of against group members or in socially unapproved methods. But the recurrence of individual murder by group members against group members indicates that this particular strategy is far from perfect. Whether a murder is the result of a momentary impulse or of a covert premeditation, it's accomplished in a single, instantaneous, and irrevocable act, and by its very nature, every individual murder cannot have been prevented. So all that any of our governments to whom we turn for security can do is to provide us with second-best remedies. One of these remedies is apprehending the perpetrator after the fact, after the murder, and punishing him in elaborate legal procedures and ceremonies. Now, this may provide some satisfaction, some sense of vengeance to those who love the victim, and it might provide some odd and essentially irrational reassurance to the rest of us that by punishing that particular murderer, each of us has somehow or other been made safer from suffering the same sort of crime. Those of you who have studied criminal law know that the debate rages over the deterrent value of punishment, but even assuming that ex post punishments do in some statistical sense deter the future commission of many of the same sorts of crimes, that form of deterrence suffers from the problem with the individualization of all statistical projections. There can be no assurance that the punishments, no matter how notorious they may be and how high the statistical probability, will deter their commission in our case. In some traditional cultures, a murder can be expiated by the payment of blood money, and we have a Victim of Crimes Act which has some similar sort of updated type of sanction, but what rational victim, prospective victim, would think of compensation as an attractive swap? We all want to avoid being murdered. Yet in terms of community remedies, both punishment for murder and compensation to survivors are not real solutions. They're second-best solutions, about the best we can expect. Now, ladies and gentlemen, my subject today is mass murder. And mass murders may seem to be merely an accumulation of many individual murders. But in terms of the preferred solution of prevention, a solution which I submit is unattainable for individual murders, mass murders are quite different, because many of the individual murders that comprise a mass murder are preventable. Unless the mass murder is accomplished with a single devastating weapon of mass destruction, a nuclear weapon, chemical weapons, the business of killing a large group of people takes time, communications, and organization. It requires assembling the victims, transporting them to the killing grounds, assembling and maintaining the killers and their tools and providing for their upkeep and arranging logistics, buying ammunition, and transporting it to a selected destination, disposing of the bodies, all the gritty details that go into setting about murdering a great number of people. But because mass murders are an organized social activity with a temporal extension that increases in proportion to the number of victims, others can quickly verify that the individual murders which have been perpetrated until that moment are only the beginnings of a series which is going to be repeated and repeated and repeated until the targeted group is annihilated to its last man, woman, and suckling babe. This means that unlike individual murders, the vast majority of which can only be punished after the fact, many of the individual murders that comprise a mass murder can be prevented. Prevention can be accomplished by arresting the mass murder process as soon as it becomes apparent that the mass murder is imminent or underway, thereby restraining the number of victims from expanding to whatever totality the perpetrators are seeking. In short, If long-term socialization, punishment, and compensation are all a community can do when confronted with individual murders, those manifestly second-best remedies are not the only thing that can be done for mass murder. Even if the mass murders at the beginning of the series cannot be prevented, and may prove just as instantaneous and irrevocable as any other individual murder, the remaining deaths that together comprise mass murder can be prevented. Now, I have no objection whatsoever to prosecution and conviction of killers, be they individual or mass killers. But if life is the most precious of things, then I ask you, should not acting before the fact to prevent, as opposed to acting after the fact to punish, be international law's primary technique for dealing with mass murder? Genocide is one form of mass murder that's been considered especially hideous. Yet, from the time it was prohibited as a legitimate strategy and raised to the level of an international crime, the global community has preferred to invest its efforts in punishment rather than prevention. Consider the Holocaust, the systematic destruction by Nazi Germany of 6 million Jews. It extended over a span of 3 years. Hitler declared the final solution in 1942 at Wannsee, and the physical destruction continued until the Reich was defeated in 1945. We now know that President Roosevelt and Prime Minister Churchill learned about the genocide while it was being pursued. Declarations of severe punishment for its perpetrators were solemnly issued, but not one single B-29 Flying Fortress was dispatched to bomb the rail lines carrying victims to the gas chambers, or to destroy the gas chambers themselves. And it wasn't for lack of opportunity. For example, at the same time, thousands of sorties were sent out over Dresden to destroy a city which wasn't even a military target. Instead of making the most minimal effort to prevent notorious and systematic mass murder, the Allied powers took the easier course, punishment after the fact. 6 months after Hitler had taken his own life and the German armed forces had issued their instrument of surrender to the Allied powers, the first international war crimes were held in Nuremberg. In all, 200 war crimes defendants were tried, but only 24 members of Hitler's elite circle were prosecuted, the so-called major war criminals. 12 men were sentenced to death. The international human rights movement has celebrated Nuremberg as a vindication of human rights and a milestone on the road to installing a regime for the international protection of human rights. That celebration tends to obscure the fact that no efforts were made to arrest or prevent the genocide that had led to the Nuremberg trials. Nor has the precedent of Nuremberg prevented later atrocities in the Balkans, Cambodia, Rwanda, Sudan, to name only a few. Quite the contrary. In each of those mass murders, little or no effort was made to prevent or arrest them. In each, the preferred strategy has been Nurembergian, to wring hands, but wait for the mass killings to play themselves out, and then to establish international criminal tribunals. After the trials at Nuremberg, the belated reaction to the Holocaust was, of course, the Convention on the Prevention and Punishment of the Crime of Genocide. It was approved by the United Nations General Assembly on December 9, 1948, and opened for signature on that day. Came into force a year later, or 2 years later, 3 years later, after 20 states had ratified it. And its adoption has been hailed as a major human rights event. Genocide is defined in Article 2 of the Convention as any of the following acts: killing members of the group, causing serious bodily harm. You can see them on the screen. I need not read them to you. Article 3 provides that the following acts shall be punishable, and they're on the screen as well. punishable acts, yes, but note the lack of emphasis on the prevention of preventable acts. To be sure, the title of the Genocide Convention is The Prevention and Punishment of the Crime of Genocide, and Article 1 gives priority, apparently, to prevention, as you can see in the PowerPoint. But the apparent priority given to the prevention of the genocide in the title and in Article 1 is actually quite misleading. Most of the rest of the convention deals with punishment after the crime has been committed. Article 4 obliges states parties to punish persons committing genocide, as you can see, punishment after the fact. Article 5 requires state parties to enact necessary legislation to give effect to the convention, and in particular to provide effective penalties, punishment after the fact. Article 6 states that persons charged with genocide shall be tried by a competent tribunal, punishment after the fact. Article 7 removes genocide from the category of political crimes for purposes of extradition, punishment after the fact. Every one of these provisions deals exclusively with punishment after the fact. None deals with prevention. The only provision in the entire convention that clearly addresses prevention is Article 8. And as you can see, it provides a rather soft set of obligations. Surely there was some sort of legal strabismus here. Genocides are likely to be perpetrated by governments within their own territories. So obliging those same governments to prevent and punish genocide is on the order of solemnly assigning the proverbial fox to guard the henhouse, and then pretending that you've taken meaningful measures to protect the roost. As for the governments of other contracting parties who might be enlisted to take some sort of action to prevent or arrest the mass killing, the duty assigned to them by the convention in Article 8 is pretty light. They may call upon the competent organs of the United Nations, not they shall or they must, they may. And upon whom may they call? At that time, the only organ in the United Nations that was competent was the Security Council. So what was the duty of the members of the Council to whom the Genocide Convention was assigning such responsibility? All the convention's drafters expected them to do was to take such action as they consider appropriate. The states parties to the Genocide Convention did not even try to require the permanent and non-permanent members of the Security Council to exercise the powers of the United Nations Charter accorded to them to prevent or arrest mass killing. Article 8 was a timid and contingent treatment of the issue of prevention of genocide. In the universe of the Genocide Convention, all that any state party could do was to call upon the Security Council. Considering the gravity of the offense, it is astonishing that no provision in the Genocide Convention imposed an obligation on each state party to act to prevent or suppress acts of genocide. Now, ladies and gentlemen, most of you are relatively young, and so for your entire lives you will know the mantra that has been endlessly intoned at the time of the conclusion of the Genocide Convention and ever since was, never again. The mantra notwithstanding, since the convention entered into force, there have been many mass murders. In international law and politics, the remedy du jour for virtually all of them has not been to try to prevent or arrest them as they were occurring, but to wring our hands, issue condemnations and resolutions, allowing them to run their course, and then to establish international tribunals and punish a few of the perpetrators. And incidentally, there's no evidence that any prosecution has served to prevent any subsequent mass killing. Consider only a few examples. The destruction of in Kampuchea, of an estimated 1.7 million people, 20% of the country's population, between 1975 and 1979, was accomplished as the world looked on. The facts were clear. Hundreds of thousands of people were brought to killing fields where they were forced to dig their own graves. They were then either shot or beaten to death with iron bars or buried alive to save bullets. In the notorious S-21 camp, 14,000 prisoners were killed. 14,000. 7 survived. The media reported many of the incidents, but until 1978, when Vietnam invaded Cambodia, no foreign government made any attempt to stop the mass murders that were taking place before the world's eyes. On the contrary, some of the leading states in the world community seemed more concerned about the protection of Cambodian sovereignty than preventing that sovereignty from being used to murder over 1 million human beings. When Vietnam invaded Cambodia in 1978, drove Pol Pot's forces from power, and finally stopped the mass murder, the United States led a group of states within the United Nations in a move to deny the new Cambodian government its seat in the General Assembly, insisting that the Khmer Rouge was still the legitimate government. During the 1980s, the United States reportedly gave $5 million in aid to the Khmer Rouge to fight against the Heng Samrin government. The international community neither prevented nor arrested the mass killings. Now, almost 30 years, almost a decade after the death of Pol Pot, the United Nations has set up a hybrid tribunal to punish the few surviving leaders of the Khmer Rouge. 5 people are under indictment. They're all over 80 years old. One has already died in confinement before he could testify. Whether or not the trials actually take place, the point of emphasis is that as the international human rights movement focuses its attention on the trials, it ignores, in my view, the real lesson to be drawn. Nothing was done by the international community to prevent or arrest the killing. In Rwanda in 1994, in the period from April 6th through mid-July, little more than 3 months, 500,000 Tutsis and thousands of moderate Hutus were murdered. The United Nations, which actually had a force in the country, had been forewarned that mass murder was being planned, yet it elected to withdraw its force, incidentally over the protest of the leader of the peacekeeping force, General Romeo Dallaire, in my view a real international hero. The United States, France, and Belgium also had advanced warning, and all refused to make any effort to prevent or stop the massacre. The United Nations Security Council similarly refused to do anything to prevent the mass killing. But after the massacre, the United Nations established a special international tribunal to try those responsible for genocide. I think the most devastating part of this very brief account concerns the mass killing currently being perpetrated in the Darfur region of Sudan. That conflict, which began 5 years ago in 2003, has claimed over 200,000 lives and displaced almost 2.5 million people. An estimated 4.2 million people in Darfur are in need of humanitarian assistance. The government of the Sudan has broken repeated promises to rein in the militias in the region, and Darfur rebels have shown little interest in negotiating a peace treaty. Meanwhile, the suffering of people continues. Now, of course, there have been plenty of declarations. The United States Congress declared the fighting in Darfur a genocide in 2004, and then Secretary of State Colin Powell followed suit. Other countries have referred to the mass killings as ethnic cleansing rather than genocide, which seems to me to be a frivolous semantic distinction. A woefully inadequate military force was finally dispatched, but despite widespread international denunciations of the Sudanese government's role in what are clearly mass killings, the killings continue. So what has the Security Council, the repository of responsibility for prevention under the Genocide Convention, done since 2003? It's passed resolutions on Darfur, but once again, the emphasis has been on punishment after the fact and not prevention. In March 2005, the Security Council passed Resolution 1593, referring the atrocities in Darfur that were still going on to the International Criminal Court for investigation and prosecution. And many people congratulated themselves that the United Nations had finally established an accountability mechanism to end the culture of impunity for perpetrators of mass killings. But had they done that? Very few people saw the irony of the situation. In Uganda, where similar actions were going on, and where the United Nations and this International Criminal Court had taken a similar position, the Catholic Archdiocese Justice and Peace Commission said to start war crimes investigations for the sake of justice at a time when the war is not yet over risks having in the end neither justice nor peace delivered. And that's certainly the situation in the Sudan. Sudanese authorities have consistently refused to cooperate with the International Criminal Court. Sudan, then, is a case of neither effective prevention nor, as I can see, effective punishment. Now, at long last, a force made up of the African Union and United Nations forces is being dispatched. But it is not until earlier this past year that after receiving the long-awaited permission of the Sudanese government, the Council agreed to deploy a peacekeeping force of up to 26,000 military and police personnel. The forces have not yet been deployed, but it's already pretty clear that they're inadequate given the scale of the activities there. Some of you may be thinking that I've painted an overly somber picture. Please keep in mind that the cases mentioned are the few instances in which states have come together to attempt to remedy the act of mass murder at all, even if largely through declarations. Other such atrocities go virtually unacknowledged by the international community. And here's an example. In January 1971, Idi Amin, the commander of the Ugandan army, overthrew the elected president, and he held power for 8 years. And during that time, the number of people killed by Amin's government is estimated to have ranged from 80,000 to 500,000. The mass murders were widely reported. Despite this extended period of mass murder, Idi Amin was elected head of the Organization of African Unity in 1975. And from 1977 to 1979, Uganda was elected to the Human Rights Commission of the United Nations. The killing likely would have gone on had not Tanzania in late 1978 invaded Uganda and overthrown Amin's government. Amin fled to Libya and then to Saudi Arabia, where he was given asylum, as voices were raised, believe it or not, over Tanzania's violation of Uganda's sovereignty. Amin died in 2003 in a Saudi hospital without ever standing trials for what he had done. So the score in Uganda is no prevention, woefully belated arresting, whose lawfulness was actually challenged, and no punishment. As strange as it may seem, many international lawyers have taken issue with the few effective efforts to stop ongoing mass murder. Consider NATO's action to stop the mass killing which occurred in Kosovo in 1999. NATO, without authorization by the Security Council, bombed Serbia into submission. Kosovo is currently under United Nations supervision. What's fascinating about this one case of relatively rapid international action to stop mass killing is that it was widely criticized by the international legal custodians of the world community. The Danish Institute of International Affairs, which was convened to do a study for the Danish government, felt that the United Nations Charter prohibits such unilateral humanitarian actions. The Dutch Advisory Committee, which was convened to apprise the Dutch government on issues of public international law, concluded that Article 2, Paragraph 4 of the United Nations Charter, quote, lays down a peremptory ban on the use of threat of force and hence does not leave any legal latitude for armed intervention on the territory of another state without the latter's consent. The House of Commons did 4 studies because of the public concern about British participation in the NATO action, and it concluded that the action was of dubious legality in the current state of international law, but it did say that it was justified on moral grounds. The Kosovo report, which was prepared by the Prime Minister of Sweden, or at the initiative of the Prime Minister of Sweden in 2000, also stated that the initiative taken by NATO was illegal because of the lack of approval by the Security Council. But it also acknowledged that it was something that was the right thing to do in the circumstances. The concern over this particular issue reached the highest levels of the United Nations, and in 1994, in 2004, then Secretary General of the United Nations, Kofi Annan, empaneled something that he called the high-level panel to prepare a report, in particular on this issue. And here's what the report said. We endorse the emerging norm that there's a collective international responsibility to protect, exercisable by the Security Council, authorizing military intervention as a last resort in the event of genocide, etc. You can see the text. This statement, which I was chatting with Professor Sharp earlier in the day about it, some people celebrate as a major step forward. In my view, it's conservative, radical in some fashion, and essentially vacuous. The conservative element is that it merely confirms that the Security Council has an authority which it had in any case. The Security Council, as I'll have occasion to mention in a few moments, clearly has the authority to undertake the kind of measures that the high-level panel is referring to. And that's why Article 8 of the Genocide Convention that we saw earlier specifically refers to the competent organ of the United Nations as the agent for prevention. So if you read the report, I hope it's still up on the screen, right? If you read the report, you'll see that it actually involves a certain retreat, as if relatively clear law that it has now been reduced to the status of an emerging norm. We endorse the emerging norm. As if clear law had somehow or other been slipped back into the womb of lawmaking to reappear at some moment in the future and when none of us know. And the notion of an emerging norm when it comes to authorizing the use of force is a very slippery idea. When will it emerge? Will it then justify certain actions, or will we not know that it is yet operative? The radical element of the report is that the discretionary vote of non-permanent members of the Council, remember in Article 8, such measures as they consider appropriate, and the free veto of permanent members of the Security Council seems to have been transformed into a, quote, responsibility, end quote, to take action when mass killings are occurring. But what does that really mean? Is there any way of enforcing on members of the Security Council that they should not exercise their veto in these circumstances? What are the sanctions that will be applied to them? This is use of legal language that has no substance behind it. And consider the idea of the use of force as a last contingency. Imagine a genocide situation. Does the international community or individual members have to wait until they've gone mechanically through diplomacy and economic sanctions and a variety of other diplomatic measures before they're entitled to bomb the crematoria? Bomb the gas chambers? The most constricting part of the high-level panel is the fact that it still keeps all of the attention for arresting or preventing mass killing in the hands of the Security Council. And this, I think, should occasion us to take a brief look at the way that the United Nations constitutional structure operates to see whether there are other agencies that might be more effective than the Security Council for preventing or arresting mass killing. Recall that Article 8 turns to the competent agencies of the United Nations. At the time, the only competent agency was the Security Council. But since then, there have been many developments, and that may be different and could be relevant to us. First, no question, despite what the high-level panel says, that the Security Council is competent to declare that internal human rights violations are a threat to the peace and to order military action under Chapter 7 of the Charter. To be sure, Article 2, Paragraph 7 seems to insulate internal matters from the reach of the United Nations Charter. And it may very well be that some states still believe that mass killing of citizens is an internal matter. But if you look carefully at the end of Article 2, Paragraph 7, you'll see that it does not apply in Chapter 7 situations. So the Security Council is certainly an agency which can effectively intervene if it is so disposed to stop mass killing. But of course, the legal clarity here cannot be used to obscure the political difficulties. The Security Council is usually unable to secure the agreement of all permanent members, and so it is either paralyzed or it contents itself with passing an anodyne resolution, a low common denominator resolution to which everyone can subscribe. And the fact is that the Security Council has not proved to be effective in arresting or preventing genocide or mass killing within states. What about the General Assembly, the assembly in which every member of the United Nations, and not simply 5 permanent members and 10 members elected for 2-year terms, sit? Is it possible to appeal to the conscience of mid-sized and smaller states and hope that they will do something? And if one can appeal to their consciences, is it possible to find legal basis for their action? In the early days of the United Nations, the United States initiated something called the Uniting for Peace Resolution, which authorized the General Assembly to take up some of the issues that the Security Council was prevented from dealing with if they were matters of fundamental security, and dealing with them themselves. And this particular initiative by the United States was blessed by the International Court in the certain expenses case. They even said that the assembly deployment of peacekeeping forces was not ultra-virus if carried out for the fulfillment of one of the stated purposes of the United Nations. And more recently, in the opinion on the wall, the defensive wall or barrier that Israel has tried to erect between the occupied territories and metropolitan Israel, the court has actually equated the General Assembly and the Security Council for certain security issues. Of course, the Security Council commands no forces of its own. The General Assembly commands no forces of its own. So, is it possible for it to authorize individual states to engage in action and make it lawful by virtue of the authority of the security of the General Assembly? It seems to me that such a case can be made, but of course, like the Security Council, this sort of analysis takes on some of the redolence of medieval scholastic philosophy when one argues how many angels fit on the head of a pin. No matter how good a legal case we make, there's no evidence that anyone has been able to engage a majority of the General Assembly to take action against a case of mass killing. And it's also clear that every case of mass killing has been known to the members of the Assembly. What about regional organizations? NATO might be considered such an organization, Organization of American States, the African Union, the Arab League. In fact, the United Nations Charter assigns a contingent role for regional arrangements in matters relating to the maintenance of international peace. But as you can see, Article 53 makes clear that this can only be done with the authorization of the Security Council. But there's an interesting development here. The African Union, which replaced the Organization of African Unity, has enacted a new constitution, and in that constitution it says that decisions of the Assembly are taken by consensus, failing which by a 2/3 majority, and the Assembly may delegate any of its powers and functions to any organ of the Union. So Article 4 purports to authorize intervention in cases of mass killing without securing the prior authorization of the Security Council. Whether that is a good development and whether that is a development that will be approved by the rest of the international legal system remains to be seen. In 1995, the then Secretary of the United Nations, Boutros Ghali, was asked by the Security Council in a sense of euphoria over the end of the Cold War and the possibilities of the United Nations operating effectively to prepare something called the Agenda for Peace. And Boutros Ghali said, and Mike, I've jumped forward to slide 17. As you can see, that enforcement action was a major achievement of the United Nations Charter, but neither the Security Council nor the Secretary General at present has the capacity to deploy, direct, command, and control operations for this purpose. And then he went on to say, the United Nations does not have a claim or monopoly over these instruments. All can, and most of them have been employed by regional organizations, by ad hoc groups of states, or by individual states. And this seems to me to be particularly relevant to the question of whether or not we can engage international organizations to play a more active role in the prevention of mass murder. Is it possible, as Boutros Ghali seemed to intimate, that ad hoc groups of states, coalitions of states, or individual states may lawfully respond and intervene militarily in a state in which mass killing is going on? Actually, the vast majority of scholars who read the United Nations Charter carefully say no. The Charter absolutely prohibits such action. A much smaller group, I'm one of its members, I shouldn't say members, we're not an organized group in any sense. Scholars resist organization. A smaller group believes that without doing violence to the language of the Charter, it is possible to make a case for unilateral action to provide remedies for severe human rights violations in circumstances in which the institutions of international law have failed to act. The General Assembly has said that Article 2, Paragraph 4 is general, but it said that there are some special situations, that's a quotation, which allow action, military action without authorization of the Security Council. Surely we would think mass killing in a state would be such a special situation. But unfortunately, the only special situation which the General Assembly has identified within that broad category is the ending of colonization. And the International Court of Justice has also taken an extremely narrow view of any opportunities for unilateral action, even in circumstances in which international institutions have failed to act. So, ladies and gentlemen, for anyone who is horrified by the prevalence of mass killing on our planet and expects the institutions of international law in the 21st century to act, or at least to authorize someone to act to prevent or arrest it, the legal situation is not encouraging. Consider, the explicit language of the Charter is against it. Most interpretations of the Charter are against it. The International Court of Justice has said it cannot be done. There is no consensus on a right of unilateral humanitarian intervention to protect victims of large-scale human rights violations, even genocides, even mass killings. There are some encouraging signs. Consider Liberia. In 1990, a very nasty civil war in Liberia led to the ECOWAS, the Economic Community of West African States, to intervene militarily without the authorization of the Security Council. The President of the Council, at a later stage, did indicate some support in a presidential statement, but there was no resolution authorizing it. But consider the intervention in Kosovo. The manifest human rights violations that were then occurring might have been invoked as the sole justification for what NATO did. But in fact, the vast majority of states in NATO did not base their action on that ground. Most of them based it on the claim that they were fulfilling a Security Council resolution's purport. That was a difficult case to make because the Security Council resolutions had been carefully drafted not to authorize military action. Only Belgium whose contribution to the NATO action was relatively small, said that the action was based entirely on a unilateral humanitarian intervention. Tony Blair, who led his government in the unilateral action, stated, and if this is slide 20, Mike, a limited use of force can be justifiable in support of purposes laid down by the Security Council, but without the Council's express authorization. And then he spelled out some conditions for this. But in fact, if you read the entire record, the later statements of the United Kingdom link the justification entirely to purposes articulated in Security Council resolutions. If it sounds bleak, I'd like to conclude with a relatively encouraging development, and it's one that's quite recent. In February of 2007, the International Court of Justice issued its judgment in the case concerning the application of the Convention on the Prevention and Punishment of the Crime of Genocide, Bosnia-Herzegovina v. Serbia. The case had been initiated by Bosnia and Herzegovina against Serbia and Montenegro, and it had been started actually almost more than a decade earlier. The judgment has disappointed many people, and it's been criticized, and I think there are grounds for some criticism. But to its credit, the court's judgment has tried to expand the responsibility of individual states to act and prevent, to arrest genocide. I don't think that the court's beginning was very auspicious. It said, well, the best way of arresting and preventing genocide is vigorously prosecuting it. I don't think there's any empirical evidence, I've said, that supports that view, but one can understand why an institution of international law committed to adjudication would take that position. But then the court moves on to a much more positive note. It says, this is 21, it is not the case that the obligation to prevent has no separate legal existence of its own, that it is, as it were, absorbed by the obligation to punish, which is therefore the only duty the performance of which may be subject to review by the court. And then it says, even if and when the organs of the United Nations have been called upon, this does not mean that the states parties to the convention are relieved of the obligation to take such action as they can to prevent genocide from occurring, while respecting the United Nations Charter and any decisions that may have been taken by its competent organs. This introduces something that is not found in the convention. And I think that this is particularly important because, unlike much human rights lawmaking, which often promises things that cannot be fulfilled, and in many circumstances I think their lack of reality is appreciated even by those who are enacting them, this decision by the International Court is carefully crafted to make it very realistic. The court is not involved in such an exercise. It says that the obligation in question is one of conduct and not one of result, in the sense that a state cannot be under an obligation to succeed, whatever the circumstances, in preventing the commission of genocide. The obligation of states parties is rather to employ all means reasonably available to them so as to prevent genocide so far as possible. How is this to be accomplished? The court says there are various factors. They vary greatly from one state to another, and they include, as you can see, capacity to influence. The capacity depends upon the geographical distance of the state, the strength of the political links, as well as the links of all other kinds between the authorities of the state and the main actors in the event. So this is quite a realistic set of guidelines for an obligation to prevent. The failure to prevent, the court goes on to say, is a violation of the obligation on parties to the Genocide Convention, but it does not necessarily slide into the crime of complicity in genocide. But if you look at number 26, please, you'll see that the court acknowledges that in some circumstances a failure to prevent may in fact slide into a complicity in committing genocide. Now, of course, the bottom line in this case was that the court found Serbia guilty of failure to prevent. And in an odd sense, the failure was a great relief to Serbia, which was very fearful that it was in fact going to be condemned for actually having committed genocide, which I, as an individual scholar, believe it should have under the facts that were available. But the implication of the court's theory of the duty to prevent will have implications for other genocides, one of which is being carried out as we speak. So, ladies and gentlemen, 60 years after the conclusion of the Genocide Convention, the shadowy obligation of the convention imposed on individual states parties to prevent or arrest genocide is beginning to get a modicum of legal substance. The court's handiwork is creative and realistic. It goes about as far as one could expect an international tribunal, especially the International Court, to go in a lawmaking excursus. But I caution you, let's not slip into the self-gratifying and premature chorus of congratulation that has been such a feature of international law's efforts to deal with mass murder. Let's take careful stock of what's actually been achieved and what remains for you and your generation to achieve. Genocide, first, is only one form of premeditated mass murder, so the court's amplification of a duty to prevent genocide is likely to lead to scholastic debates about whether an imminent or ongoing instance of mass murder qualifies as genocide, when I think we should all agree the debate should be about how to avert or arrest it as soon as possible. And we already have an example of this hair splitting in the initial international reaction to the mass killing in Darfur. Given the court's considered resistance to the lawfulness of any unilateral military action, the reiteration of the restraint on what is really the only effective method of stopping mass killings in a state, some form of military intervention, this will not be relaxed. But it still leaves a broad range of other actions that might be taken. Contemporary international law imposes no limits on the use of the economic instrument. Thus, the obligation to prevent should, under the court's theory, kick in with meaningful programs of economic sanctions as soon as it becomes apparent that a specific genocide or mass killing is being prepared, and a fortiori, as soon as it becomes clear that it is actually underway. It would seem that under the court's theory, continued provision of economic assistance to a state engaged in genocide could slide from a failure to prevent to complicity in committing genocide. Nor are there any limits on the proactive use of diplomacy. This can include various modes of pressure and even isolation, even exclusion from international organizations, and this again should kick in early. So the decision of the International Court has begun to shift attention and to provide substance for the Genocide Convention's obligation to prevent and to arrest genocide. But its innovation alone is hardly likely to change international law's focus on mass killing. As the sad case of Darfur demonstrates, I fear most international lawyers, even those most committed to the advancement of human rights, still seem to prefer the creation of more and more courts, more and more judges, with a promise of ex post convictions over actually trying to stop, if not stopping, mass killing. Now, I readily concede, preventing and arresting mass killings is a much more difficult and much untidier process than a judicial process after the fact. It is unquestionably fraught with its own moral problems and raises many other thorny policy questions. But doesn't the prospect of saving lives make it worth the trouble? Thank you.
That was very compelling.
Thank you.
We have 10 minutes for questions from the audience. Raise your hand someone with a microphone will come over. That's important because the people upstairs, the people out in the computer audience need to be able to hear as well. Please identify yourself, ask a brief question, and we'll try to get through as many as possible. And we'll begin with Henry King. Okay. Wait, Henry, here's the microphone again.
I think I agree with much of your speech. However, I think there's a matter of geography involved. I don't think things are so bad in Europe. I think you have a rule of law there. They supported the International Criminal Court, and yet they were the situs of 55,500,000 people killed in World War II. I don't think we can dismiss the conversion of Europe to the rule of law when we talk about this. I think that Germany has a provision in its constitution against crimes against peace, which I think is straight Nuremberg. And maybe the fact that Nuremberg was conducted in Europe made a difference. But I wouldn't dismiss Nuremberg from the standpoint of your thesis as having no effect. I think that it did. I was witness to it. And so I just thought that I agree with your approach. I don't have much doubt about it, and I like the regional aspects of what you're talking about in terms of the African Union. But the world isn't all bad, and also it takes time. Took over 50 years for Nuremberg to be institutionalized in the International Criminal Court. And I think progress in this area is glacial. But you're dead right in calling our attention to the weakness in this area. But don't be impatient. It takes time.
Thank you, Henry.
Other questions?
I understand you're a legal scholar speaking to an audience in a law school composed mostly of law students and lawyers, but I have to ask the question of whether legal obstacles are really what is stopping intervention. In the case of Kosovo, apparently it did not, but in most of these, it seems to be more of an excuse or just a lack of capacity that had been built up and ignored over many years to intervene in the first place. And, I mean, developing the tools is great, but people dying today don't have room for that patience. So I want to get your take on that.
I think it's a very pertinent observation, and there's no question about it. I regret that I didn't bring a quotation from a biography of Kofi Annan, which the author, a very fine biography, in which the author quotes, I believe, Nancy Soderberg, who had been in the National Security Council during the Clinton administration and was faced with Rwanda. And she's quoted as saying, "We just didn't care." And there is no question that among many people and possibly many elites, lip service is paid to fundamental human rights of on this order, but there's no substance behind them. I believe, and I think anyone who studies law believes, that one of the functions of legal formulations is to create a focus and a sense of authorization for certain actions that otherwise would not be available. It changes a variable. It permits those who are committed to human rights to agitate more effectively by reference to that norm than they would if the norm did not exist, let's say an effective norm of prevention. So I think your observation is accurate, and I think it's a very healthy response that legal formulations alone will not accomplish anything. But I think it's very important not to slip into the nihilism on the other side and assume that legal formulations will have no effect. They will be a variable that will be available for those who want to use them. Thank you for the question.
Yes. if you use force to prevent genocide, I mean, don't you have to do it right? It's like in Kosovo, wouldn't it have been better if the UN troops would have went to the area and set up a mantle of protection so that innocent lives wouldn't be slaughtered, rather than dropping bombs on TV stations, Chinese embassies, water treatment plants, and bridges in Serbia? I mean, which I'm told just exacerbated the tension. I mean, isn't there a right way and a wrong way to use force to prevent genocide?
Of course. Of course you're right. I'm not addressing the question of, in particular circumstances, what should be done and how should force, if force is the only method available that promises success, how it should be used. I'm simply trying to draw attention to the fact that the entire program of prevention has been pushed aside, both in the Genocide Convention and in subsequent practice. But I take your point. And any action, whether it's military, economic, or diplomatic, can be done wrong with negative consequences, or it can be done correctly. And there's no question also that the international legal method has ways for appraising and making judgments about whether or not the right steps were taken. I'm addressing here only the question of whether or not steps should be taken.
Sounds as though there's competing forces, countries being condemned for invading sovereign nations in an attempt to prevent genocide, and then on the other hand, finding countries complicit if they don't do that. And I was just wondering how you saw those forces playing out in the next decade or so and how it might be resolved.
If I may perhaps borrow some of the optimism that was expressed by Professor King, I hope things will be better. I hope that what I've told you today will make a difference. I hope that you'll make a difference. I don't believe there is such a thing as the future out there that I can indicate. The future really is a function of what we do as we move through a constantly eroding present. And hopefully, if we do the right things, we may not prevent every genocide or every murder within a genocide or mass killing, but we may be able to do much more than has been accomplished until now.
Thank you. You seem to have made references to international lawyers as well as international entities being able to possibly arrest genocide or mass murder. In what ways do international lawyers factor into the prevention of genocide or mass murder?
The process of application of international law is an extremely complex and modular process. It is unlike a highly organized domestic legal system in which one finds specified institutions which are charged with these actions. In international law, it's a much more fluid thing. If international lawyers are able, relying on international law, to espouse certain views, to present them to a public, to make the public aware of the implications of not acting, then they can be part of the process of stimulating decisions that will ultimately lead to more prevention. On the other hand, if international lawyers' position is there's nothing we can do, or there's nothing we're permitted to do, then they will short-circuit what otherwise could be a possible form of pressure.
Last question. Here. Okay. The honors.
Is that a colleague over there? Is that a colleague over there who's been? Yeah, someone seems to be trying to.
Okay. My question is, to what extent, if this emerging tendency of intervention to prevent mass killings as they happen or before they happen, to what extent might this trend allow states to invade or intervene in other countries for motives or reasons that are ulterior or don't primarily have to do with the killing that's going on. And an example of this that I kind of thought of during your lecture was I recall in March of 2003, about a week maybe before the U.S. invasion of Iraq, I remember seeing Condoleezza Rice saying something to the effect of, in trying to justify the invasion, saying something to the effect of, we cannot repeat the mistakes of Rwanda.
Yeah, I'm not sure I see the connection there, but I take your point. Once one suggests that in the absence of international action, unilateral action may be justified for preventing or arresting mass killing, the possibilities for abuse, for actions that ostensibly are designed to address that but actually have ulterior motives, is quite real. And one of them, and I'm very much alive to it, one of the reasons why many people oppose any type of unilateral humanitarian intervention is precisely because of its potential for abuse. But let's understand what abuse means in context. When Vietnam invaded Cambodia in 1978 and expelled Pol Pot and stopped the nightmare in Cambodia that had been conducted by the Khmer Rouge, it was unquestionably doing it for its own diplomatic reasons. But what's important, I think, from a human rights perspective, is that it stopped the killing. So I think we need to be fairly clear about what our objectives are. And we have to recognize that no one, perhaps except you and me, perhaps a few other people in this room, ever act purely altruistically. Everyone else acts for some ulterior motive. And the question here is the ulterior motive likely to bring about a beneficial consequence? I think that stopping mass killing is one such consequence.
That's a great place to end, I think. Again, please join me.